2012. This meeting is now called to order, and I'd like to have a roll call, please.
Chairman Colapetro.
Here.
Sam Vincent.
Here.
Bob Mills.
Here.
Henry Bird.
Here.
Bob Finnis. Rex Sims.
Here.
Fred Forbes.
Here.
We have a fairly full agenda this morning. However, we are going to ask for some brief, if you would please, public comments on the agenda items before we start. If you have something you'd like to bring up, please do so. State your name for the record, and I'd like you to take 3 minutes if you can.
Good morning, Christine Ross from the Bonita Springs Area Chamber of Commerce and also the Bonita Springs Estero Economic Development Council. I appreciate that you all are working on a referendum regarding mobile food vendors, and I just want you to be cautious and to remember to think about the impact this would have on the Hungry Hound Dogs, who has already gone through quite a bit to establish his facility and spent quite a bit of money to make that a semi-permanent opportunity. So I would encourage you to find a way to grandfather him in some fashion if you are going to move forward with this today. Thank you.
Good morning, gentlemen. My name's Charles Bastinet. I'm an attorney with Henderson Franklin and Fort Myers. I'm here today to speak to you about the mobile vendor ordinance also. There's also Rick Price and Phil Pugh. What we'd like to do is reserve our time for when the item actually comes up. We've got, all three of us have brief statements to make. Thank you.
Anyone else?
Hello, my name is Christy Sofer, and I'm a resident of Bonita Springs, and my husband owns the Nosh truck, and he has mobile food vending, and he will also be impacted by this, and he also has followed every regulation that he needed to operate in the state and the city, and I'd like you to consider him also your grandfather if you choose to pass this today.
Thank you. Anyone else? Okay, we will then move to, I guess it's going to be item 4 now. We're going to review the following ordinance for consistency with the City of Bonita Springs Comp Plan. A.
Thank you. The first ordinance we're looking at, and you've seen it before, is what we call the Miscellaneous Land Development Code Chapter 4 changes. I do not need to read the title block in the record, so I will not, save some time. I do want to point out, since you looked at it, council also looked at it. Let me find my notes here. And certain changes were made after your meeting. You have in the backup the December 4th, and those were the backups that were, or changes that were made after your meeting, along with some changes that are identified in the green sheet for December 19th. I'm just seeing if I have that here. I thought I did.
November 19th?
No, for the December 19th meeting,
Oh,
yes.
okay.
I believe it was handed out to you. It's in your packet. It would be green sheet 1212-0391.
Yes.
Okay, good. You have the backup, including the changes that council did. Council, one of the changes was in 4-2019. They took out additional uses such as the charitable collection drop-off boxes. That was one that was done by council at the meeting. And I believe there was one other change. I'm not finding it right now.
Bless you.
I believe there was additional clarification and corrections dealing with the use regulations. There was a leftover from a prior initial draft that had special exception in Group 2 for horticultural waste. Now you have that as Essential Services Group 2 special exception. And the only change inside the is a reference to the note to 1831 in that portion, as well as that part was removed. At this time, Alexis Crespo can answer any questions, if you do have any questions onto it. Your changes were made.
Gentlemen?
Question, is this the ordinance that we dealt with at the last meeting where?
Yes, sir.
We were talking about administrative appeals and?
Yes, and I provided you a memorandum, and I've given council that memorandum dated, and that's the memorandum dated November 19th, which was a follow-up to your November 8th meeting, explaining reasons, the legal reasons, why you do not want administrative appeals to be applied to third parties. Staff also has objections to, in addition to legal, there's some practical objections also by the city manager.
And the suggestions that we had at that last meeting have been incorporated in here?
Of course.
Yeah. Mr. Chairman, I had a good discussion with our esteemed city attorney, and I agree with her that we don't want to give the surrounding property owners the right to appeal. But the one thing that happens when you do administrative approvals versus special exception is that the surrounding property owners no longer get notified of something that's going to happen on the adjoining property. I feel that we need to amend this ordinance or write a separate ordinance that puts a requirement on the city that when somebody comes in for a administrative approval of either a use or a zoning variance, that the surrounding property owners within 300 feet, not counting roads and right-of-ways of roads, shall be notified, and that the administrative approval would not be granted or dealt with until 14 days after those surrounding property owners have been notified. They do get notified automatically if it's special exception, it goes in front of city council. They don't the way this is written up. That's not granting them the right to appeal it. All it's granting is what the city attorney has said is the right of any property owner, which is to lobby their city council member or other city council members.
May I make a suggestion?
Yes.
That would be, if you go to page 18 or 19 of the draft ordinance dated December 5th,
Yeah.
that's section 4-204 submittal requirements for administrative action applications. We could add a sentence in here is that no administrative approval will be final until 14 days after notice is provided. Jackie, either pursuant to the section requiring 375 or...
Jacqueline Ginson for the record.
Well, the only thing is, I think they need to be notified before the decision's made.
Well, that's...
Are you asking to do this for all applications that require administrative approval? Because there are quite a few.
Uses, special, and zoning variances is the only thing I would be concerned
I mean,
with.
the only variances we do give, or that staff is granted to approve administratively are, it's in section 4-262, and it has to deal with setback variances, if it's a non-conforming lot, legal lot of record, or if it's because of eminent domain. So there's a very finite list that staff is authorized in terms of granting variances. We never, ever grant any use variances ever, because that's a special exception or a rezoning.
Well, yeah, but as we've been getting ordinances which are going to the city, each one that I can remember, there's always one or two what was called SE, special exception, lined out, and then AA as a proposed change. Now, City Council has not always accepted that, but there's a move to go to more administrative approval of what used to be special exceptions. And I'm not necessarily against that. I think that's good. It speeds up the process and all that, but I think surrounding property owners certainly have the right to know that something, a different use has been applied for well before the decision is made. And that's That's not granting them the right to appeal the decision. It's simply giving them the right to contact their city council person if they're not happy with it. That doesn't mean it's going to change it, and it probably won't, you won't have that many, but it's a right they have now, and every time we move something to administrative approval, they lose that right. So, and that's not granting them anything more than they have under special exception right.
Mr. Chairman,
Yes.
along those very same lines, I have a additional question about this process. And as you recall, a year or so ago, we adopted a lot of these administrative changes so that it would speed up the process for very simple special exceptions. It didn't take 3 or 4 months to do them. And we're all in favor of that, but I've had a little thought about this. On page 11, for example, it's talking about the duties of the zoning board. And when a person would go before the zoning board for a special exception, the zoning board had the power to grant that special exception, but at the same time, they had the additional power to add conditions to that special exception that weren't necessarily listed in the, and we've had several cases of that where it required a change of access or various setbacks and so forth. So the zoning board has that power. My question is, when I'm thinking about this, is when they would go to John for a special exception, would John have that power?
John legally has the power to put conditions that are necessary that reasonably relate to that special exception or variance. He would not have the authority to put something that is outside, and neither would council, neither would the zoning board make recommendations to have.
How is that defined? I don't see
It's
any.
more of a legal standard of it's kind of hard with Chuck Bassinet in the room because Chuck's probably laughing at how I have to explain this. He is deciding how far staff can push a property owner to make sure it reasonably relates to the area. Some property owners are very cantankerous and no way, no how, anything. And usually those will go into hearings because if John feels it's outside of his authority, he's
Okay.
not going to go farther
All right,
with it.
well, we'll grant that John has that power. So my next question is, when you receive a special exception for a particular use of that property, how long does that last?
It runs with the land
Forever and ever?
unless certain conditions are placed in there. So, for example, a lot of times, in all of them actually, in the alcohol ones, I believe the stage is different too, but there are conditions if there's a change in use, if there is a cessation of more than 6 months.
Okay, if the property changes hands, the special exception goes with the property.
Yes, sir.
So most of the special exceptions that have been granted, or the majority of them, I believe, are for outside seating.
You've had a few also for some, the horticultural waste transfers that
Okay.
just went through.
But in the beginning, at least when we started out, I think 7 of them were for outside seating.
There's some
And-
form of alcohol.
And so, well, in my case, I didn't serve alcohol, but I have outside seating. But, I mean, that is an example. My question is, as this property would change hands, and the adjoining properties have different uses, for example, that might be more intense than they are now, can that special exception be revoked in any way?
If the property owner is using it in conformance with the special exception, why would we revoke it?
Well, I was wondering, because once you grant this, it's the same essentially as a
Right.
permanent zoning change.
Yes, it's exactly the same as a permanent zoning change. And let me go through, every time we get a new city council member, every time we get a new zoning board member, one of the words that comes out of my mouth is you never, ever make a decision based on whether you like someone or you dislike someone. Because they could either drop dead,
Yes.
they could sell the property, and you want that use to be compatible at that location. You don't don't look at personalities of what you think about somebody, whether good or bad.
Well, going back to my original question about the zoning board as it applies in Bonita Springs is essentially a judicial orientated.
It's a quasi-judicial now, and what they do is they only give recommendations, similar to like a DOA hearing, where the hearing officer takes in the evidence, does the initial review, does the initial recommendation, and then it's up to city council to either adopt those findings and recommendations, or alternatively reverse them.
Gotcha. But it's a judicial organization, but John is an administrative position. Is there, are we building a conflict there? Are we building anything that doesn't exactly fit?
The concern I have from a legal standpoint is when you do things administratively, you do not have the same record that is created as if you went through the quasi-judicial function. But when you go through the quasi-judicial function, whether it's a hearing examiner or whether it's a zoning board, it's costly, and because you have a court
Sure, I
reporter
understand.
there, we're taking evidence, we're swearing people in. I'm there. City pays me no matter what, but I'm not on John's shoulder while John is taking evidence in. John's not swearing in folks. He's making his judgment based on his judgment calls. So if there is a dispute, it's a lot messier from a legal standpoint because there is no record, so it's a de novo review as opposed to a secondary review. So the courts are able to have a lot more flexibility, which again makes it messier.
Well, the only doubt in my mind that is coming is that John could essentially, through a special exception, change a land use forever and ever and ever that would be forever binding on that, and yet it's not. It was done administratively and not judicially.
No, sir. There are no administrative special exceptions. So if somebody applies for a special exception, it will go before the zoning board and also the city council. We do not review any of those administratively.
Administrative approvals are not called special exceptions.
Well,
They're taken out of the special, and that's the second point, which is once you do an administrative approval, it's no longer a special exception because you no longer need the vehicle of the special exception.
Okay. All right.
So council can always say, we don't care about a particular horticultural waste. Right now, we're requiring special exception approval, and, they may later on say, no, staff, you can administratively do it if we have parameters in place to address it. And that would make things happier for the people that are trying to get the thing processed because they're not put through the ringer, they're not going through hearings. It makes things easier, but at the same time, and you're right, but it's a permanent land use until somebody changes it, because nothing's ever permanent in land use.
Hold on one second. Hold that thought. I want to interject something here. My problem with the administrative approval portion and the third party thing, not having any rights on that, is that when a decision is made, and I wound up on the short end of one of those decisions, that changes a lot size that was agreed to on the development order, and everybody shows up that's property owners either right next door to them or right across the street, and everybody voices their approval except for the developer who threatens to put up a condo, which would have butted up against the back of a trailer park's storage area, and he got the exception. They shrunk those lots from 135 to 55 feet.
And that one went to court, and the people who had problems with it, again, administratively, they could not appeal the decision. They did what they were allowed to do. They went to court and challenged it. And ultimately, after, it felt like a year, was it?
About a year.
Yeah, roughly a year, they finally settled it. Everything had settled through mediation.
Oh yeah, they're roof line to roof line.
But the point of that is that we keep referencing there is no appeal. Well, that's not necessarily correct. What you're doing is defining what steps you have administratively. Just like those owners and that development had the right to appeal a decision in circuit court, other people have that same right, assuming they have standing. What we're defining is simply what can you handle administratively? What is handled by the city council? What decisions can they make prior to that step of going to court?
Okay.
And the example you gave went to court. You know, property owners, and you could have joined in on the lawsuit if you desired, if you had standing. Property owners did sue. They did survive standing challenges. They survived motion to dismiss challenges, everything else by the developer. Proceeded through court, and eventually it settled, but through several hearings.
Okay.
Mr. Chairman?
Yes.
It seems like what I've been hearing here has to do with the power of the position and what John can't
Right.
not approve. Is there a way of listing that sort of thing for ease of reading and understanding? Because to go through all of the ordinances is quite lengthy and sometimes confusing.
Yeah.
I'm wondering if there is something that could simplify the power of that position.
Probably easiest if we break it down into the types of approvals. If we're looking at uses, Mr. Forbes brought up the uses that were changed in that agricultural overlay. Now, that's the only place where those uses applied, but you had referenced previous special exception uses were changed to administrative approval. And there are some that are simply permitted by right. So if we know exactly what you're wanting in a list, we can prepare a list. But there's a number of areas and...
I was thinking of the public when they read someone is a professional that's authorizing them or advising them to know without having to delve into Chapter 4 fully.
Sure. The easiest to look at is there's a section, it's not in the draft here, in making amendments, administrative amendments to like plan developments. Now this is different than other types of administrative approvals. John cannot do things that create external impacts. He cannot do things to reduce the amount of open space, and there's a third one.
Buffers.
And buffers. Is that the three?
Those
Okay.
are the three.
Do remember.
How will a person know what avenue to go, John? How a citizen comes in and he's got a problem how do you know what avenue to take?
For what type of situation?
Well, for
I'm not sure I
special
follow.
exception administratively, for example.
If are you talking about their intention to be an applicant or they wish to appeal?
No, I'm an applicant coming in cold turkey, and how do I know what to do? It's not really defined here.
It's listed in the Land Development Code in Chapter 4. You have tables that state all of the uses that are permitted in different types of zoning districts, and the process for approval, whether it's permitted, special exception, administrative, or whether it's not permitted at all. So there is a location to go through and look at that table to see which use you are, to see which zoning district you are, and to see if that use...
And see what you want to do. And okay,
Yes,
I
sir.
get the picture. That's good with me.
So it's incumbent on the applicant.
It is, but we receive
They're
numerous
very
phone
helpful
calls
over
for
there when you
verification.
go over and don't know what you're doing. They're very helpful
Yeah.
in helping you do it.
Yes, sir. That's if somebody is not sure either their zoning district or their specific use, because our uses are, I'll say, use some antiquated terms. We're more than happy to answer those questions.
Staff has been exceptional in that
Yes, sir. Thank you.
situation.
Fred?
Yeah, couple things. Number one, I believe in this ordinance, you're proposing to change co-op parking lots to be administrative approval.
That's a little further down the list, but yes, sir.
Yeah, okay, so this is an issue, and you're correct, that once it's moved over from SE to AA, it's no longer a special exception that somebody's coming in for. So I go back to, and then I've got a point on the co-op parking lot. That's not a big deal, but I think it's important. I would like to make a motion that at least the surrounding property owners within 300 feet, excluding streets and right-of-ways, must be notified if somebody comes in to get an administrative approval for a use. Because otherwise they're not going to know about it. Right now, if it's special exception, they know. But when it goes into administrative approval, that piece drops out of the process. And I want to make sure that they don't make a decision for at least 14 days after the surrounding property owners have been notified. It doesn't grant them the right to appeal. It simply makes sure that they do have the right to exercise, to lobby their city council person or other city council members. And we're not really giving them anything more than they have now, except that whenever we move something from a SC to a AA, that piece of the process drops out. And we're still not going to really retard economic development or make us business unfriendly. We're simply granting that, keeping the right that people already have that have paid money to buy and live in Bonita Springs.
Can't that be made part of the ordinance?
Could
It
be.
can, but I think that we need to keep focus on one thing. The intent of having uses or certain permits go through the administrative approval process is, as opposed to a public hearing, is because their impact is either negligible or there is no impact, it's actually a benefit. So if the concern is that the uses that you're putting under administrative approval would have a negative impact on adjacent property owners, then you probably shouldn't recommend they be approved administratively. It defeats the purpose of having an administrative process.
I understand that argument, but I do not see where it's impeding progress to allow a surrounding property owner to know that something is being asked for on a use that they may or may not like until they find the bulldozer out there digging the footer to build it or whatever.
Well, the types of uses or the types of, I'll call it permission, that you're granting with administrative approval, you pointed out the shared use of parking.
Right.
And with that particular application, there is no bulldozer. There is theoretically no impact. We have an applicant
Right.
that is just talking with us now that has a multi-building commercial project. And within that project, there's a restaurant and there are other retail uses and office uses. And one of the restaurants wanted to expand but didn't have the parking. However, the rest of the shopping center does.
Right.
Being on a separate parcel, they need an agreement to share that parking.
Right.
Their hours of operation are different, their peak times are different, the needs for the parking are different. So if you were to drive by that commercial development before any such agreement is approved, and then you drive by after, theoretically you would see no difference. If you were an adjacent property owner, if you're a resident living nearby, the theory is changing this to an administrative approval means that approving that just without a hearing, without notice, is not going to have a negative impact on those adjacent property owners. So it kind of goes back to what I was saying before. If you think that that process or that approval does have the potential to impact those adjacent property owners, it shouldn't be administrative. We should keep that in a hearing where people are noticed and where people do have the ability to come to the podium and speak their mind.
If I could say, John, on that topic, what you're trying to guard against is the growth of parking areas when an owner wants to enlarge. So what you're saying is if owner wants to enlarge but has an agreement, no impact would be seen.
Yes.
So it really is focused towards growth of parking lots and shopping centers, for example, or other areas.
That's exactly right. And we keep talking about this one particular item, but Mr. Vincent, I think you're exactly correct for this. I don't think anyone will be surprised if I told you that the parking standards that we currently have are probably a little high and to the point where they're unnecessary. And that's one of the reasons why we're looking at, one, to reduce the number of parking spaces, and two, to allow the joint use of spaces administratively. But this is one issue within an overall perspective, and that perspective is if you want to handle applications administratively, you should be thinking there is not going to be an impact and there will be a benefit to the community.
Going to the parking lot, let me give you a hypothetical. Assuming this is approved administratively or whatever, parking lot gets approved for 4 tenants or 4 building owners based on, and they're all relatively low intensity use parking or requirements for each one of them. So that comes up with a certain size parking lot, so many spaces and all that. Now down the road, one of those tenants gets changed out to a tenant that's very high intensive use. but this administrative approval, it goes on forever, so what happens then?
Well, the actual approval for that development with those uses is going to be through a development order and then building permit to construct the site.
Right.
And this is not uncommon. The most general concern we see is when buildings are constructed for general office and later down the road someone comes in to request a medical office, which requires additional parking.
Right.
And in those cases, what we've done is work with the property owners somewhere close by. If they have additional parking above and beyond what's required, we will allow them to enter a shared parking agreement. Now, currently, that agreement goes before the City Council as a special exception to be approved. But you have worked in the business long enough to know that waiting for a hearing to take place and waiting for an effective date is not something that most applicants like to hear. So the thought of addressing the issue, providing the parking through a shared agreement, and allowing that business to open is something that your staff did not see a negative impact upon the community. Now, if this board feels differently, obviously it's your right and your job to state so and provide us a different direction.
Can we move on?
Well, let me just go on the record. I feel strongly that the surrounding property owners should be notified. We supposedly live in a transparent society when it comes to governmental issues, and I see no harm in notifying the surrounding property owners of any requested use or whatever.
And I do agree with you on the transparency. I have no issues with notifying adjacent property owners or talking to anybody that comes in that has questions.
But if they don't know that somebody's asking
I understand.
for a use,
Is that a problem?
They can't
Put that
come
in
in.
the ordinance?
What I would put in the ordinance is on page 19, I would add a section 8. The applicant must notify adjacent property owners within 300 feet of the application pending. The Community Development Director may not make an administrative approval until 14 days from date of notice sent by regular mail. I'll probably clean up the words a little bit.
that's fine.
That
Okay.
satisfies-
Very good.
Now, I made it 300 feet. We normally do 375 feet. 300 feet is a closer. There is a cost associated with this. It comes out to about $1.50, $2 a letter because they have to get the property appraiser to give them a map.
Yeah.
So it's not cheap. So if you have some little restaurants, little administrative approval of like a single-family residential, do you have any administrative approvals that you need to make occasionally?
Home occupation.
Home occupational?
Yeah.
You have a-
I mean, for Jacqueline Genson, I wonder, is it worth is there any way we can define this later? Because there are quite a few list of uses that staff can approve administratively, and maybe you don't want this to apply to all of the uses. So, or
Would you want
administrative
certain use?
approvals. So
Right.
it just needs to be defined because
Yeah.
if we're going to give, for example, the Bonita Beach Road widening, the dog track, they're going to probably come in and ask for a sign setback variance, which is allowed in our code
Right.
for staff to approve. So is this going to be subject to
Yeah,
those
I would-
notifications?
And I would say now, I would ask that LPA consider for application pending for horticultural waste transfer, the ones that are maybe more intensive, the horticultural waste, consumption on premises. I don't know if there's other ones.
Well, I would go along with that, but I'd even, as opposed to a mailing.
Let me, did we leave it in, did the city council go along with the proposal that, what was it,
Administrative.
kennels and other things in the agricultural overlay could be approved administratively?
That's not in this draft, that was in the
No,
prior.
some of them, not all of them.
Right.
I would say things like that, the
That
surrounding
would be
property
fine.
owners should be notified.
Mr. Forbes, would you also be agreeable to maybe posting a sign on the property as opposed to mailing letters? Because mailing letters has certain difficulties with it other than cost. One is if you have tenants that are renting space, they're never going to receive the notice. It goes to the property owner.
That would be easier.
Yes.
I would agree with the posting.
Yeah, I would too.
Or why not let them bring in proof that they did it?
We can do that. Mailings in and of
No, I'm
themselves,
not
I
saying
think,
they
have
They can go knock on the door and say, here's what I'm doing, and get them to sign a little
some
thing.
sort of affidavit.
Yeah, that describes it.
It sounds great, except for the fact that, each property owner is going to handle things differently, and it can become an administrative nightmare.
I think the sign on the
I think
property
a
is the way to
sign
go.
would be sufficient. I mean, if you are an out-of-state property owner and you're not having somebody watching your property, you know, it's a little bit disingenuous to feel that you need at that point. I mean,
Yeah, sign with contact information, I think, would satisfy.
Yep, I agree.
It's the same sort of sign that we have for
I
zoning.
think you're going in the right direction.
Yeah.
I see continuing problems with it, and I don't know how it's to be resolved. And the case in point is, a neighborhood I lived in when I was a kid, they built a supermarket on the end of the block with inadequate parking. As their volume grew, people began to park on the street. Now, the houses that were closest to the supermarket, they couldn't park their own car. So they moved down the street a little bit further. Now, I live down on the end of the block, and I got a corner house, and there's no parking place for a car for my family. But you don't know that when you start out.
Well, this is if you go through the proposed text, what I think you'll see is even an increased standard over what we currently require, because not only are we requesting that you come up with an agreement with another property owner for that parking that you need, but also provide us essentially a plan B. What happens if this business decides to change uses and needs those parking spaces? What are you going to do with your parking needs then? So not only are we getting an agreement, but we're getting a worst case scenario. That way we don't have people parking down the block.
This thought is an idle thought. It doesn't have anything to do with our business here. But
I think it's right to the point.
It says the mistake was originally granted by allowing a supermarket with inadequate parking. Is there any remedy for that?
fixing parking?
It depends on what the approval was. Plan development, special exceptions, they all come with conditions that state if the situation on the site changes, or if conditions in this ordinance do not address all of the impacts, the city has the right to come back and ask you address those.
Right, and let me give the legal answer, because that might be easier. And that is, if you have a property, and say we do not have sufficient parking for whatever reason during certain time and hours, if it's so horrible or so bad, eventually I'll be asked to do a public nuisance. If it's if it's if it's going into our right-of-way, we'll be citing them for parking in the right-of-way. The neighbors next door will be citing for trespassing. And normally businesses will want to accommodate their customers, because nobody wants their customers' cars to be towed, because it's not really good for business to have your customers getting a $500 bill or $300 bill for the towing. So generally the businesses tend to be compliant in correcting things that are a nuisance.
Yeah, I hear what you're saying. The case I have in mind is for the property owner, meaning the business. As the business grows, the vehicle traffic goes up. There's no place to put it, and he has no remedy at all. He can't buy land to accommodate that traffic. He's in a, quote, the impossible situation.
Well, we have had a couple of businesses
those
that have been
situations.
successful, and there has not been the opportunity, there has not been a physical opportunity for them to even purchase land close by. We have worked with them on valet parking further down the street than what you normally see with an average business. And with that use of a valet, it gives you a little more flexibility and distance from the site.
And you have design planners who do a wonderful job. When they look at the property, they can figure out where there is unused space or the space is wasted because it's not being used correctly, and then redesign, go for a development order, and reconfigure things to correct the problems.
On this point.
Hold on a second. Rex has been waiting very patiently here to get his 2 cents
Well,
in.
have we beat this to death? We're ready to go to something else while we have John up here?
Yes.
Is it okay to, I have some concerns, John, back on page 27 and 28. I think we discussed this before, and you still haven't made it clear with me. We're talking about convenience stores and beverage stores with or without gas pumps, which in my mind is the typical convenience store that we have. And On the next page over there, we're talking about flat roof canopies. Now, I'm visualizing the canopy that we're discussing is the canopy over the gas pumps. And in my mind, that canopy serves two purposes. It keeps the rain off the customers, and it's a support for the lighting system. And other than that, I don't think it has any other function. But most of them that I see are flat roof. They're just a very simple structure to meet the wind code down here. When we change to something other than flat roof, it's not just a simple little matter here. I see it as if you take away flat roof, then it means it's some kind of
A pitched roof.
pitched roof.
A wing.
So all at once I see something that is of a substantial revision or a substantial. Am I imagining this? I can't believe that we could require this. And then the other thing that I'm talking about, we have under E, I think we discussed this before, this color banding on the structures, including canopies, is prohibited. I find that Shell Oil has a yellow with a red medallion that is their trademark, and I'm quite sure they're going to want their band up there yellow.
Usually.
I'm having a lot of problem with this.
Hello, Alexis Crespo for the record with Waldrop Engineering. The copy before you still has items D and E regarding canopies and accent banding, but at the December 5th first reading before council, we did put on the record that these items would be removed based on, I believe, comments received in November at the LPA and also from Ms. Ross at the EDC
Okay.
to remove those items. And while we're on this section, I believe there was another item that was removed on page 26. G, landscaping. This is jumping back to your automobile display rental. We're also looking to strike item G1B for the undulating berm. So there were some modifications that did not get put into this document before you that we heard at our last hearing and are prepared to.
You're striking B?
So you're striking B and
Striking B
and
for
under the
for
canopies,
berm.
D and E?
And then on page 28, striking items D for the canopy and E for the accent banding.
Okay.
Those will be.
All right.
If I can ask a question here, in other communities, other states, they have requirements that that prohibit things like this. Is that true?
Lee County adopted very similar language in the past year.
So it's not that we can't do this.
Correct. It was just seen as maybe too restrictive at this point, and we needed to reach a happier medium compared to what other jurisdictions are doing. And
then there's also sections in your Chapter 3 development standards
Right.
that address the canopy design and also being compatible with surrounding buildings if it's in a center.
Right, because I think, Rex, that it's worthwhile in certain circumstances that there is a control over banding, the colors, the sizes, and so forth. And that in regard relates to the proportion of the canopy. I mean, this gets back to some architectural decisions that are made, and sometimes this banding is just too abusive.
Okay. But along this very same line, when we start down with Shell is in the 041 overlay, and when we pick out the color chart here, I went down and looked, and Shell's colors are not in the color chart, so I can just see all kinds of complications here.
And I know we've been bouncing around, but the intent of that color palette is not to change the color of someone's logo or sign. It's to allow them choices as to what color they paint their building.
Okay.
So the color of the building is not necessarily even
I hear what you're saying.
same color as the sign.
We'll get into that pretty soon.
Yes, sir.
Okay, as long as canopy thing and this change in the flat roof have been removed. I'm comfortable with it. The only other question I have while we're up there is not really been addressed by this section, and I'm back on I'm on page 35, and the question that comes up, especially in new construction recently, the question that comes up in my mind is the lack of loading or unloading areas. And I think, for example, the worst place in Bonita Springs is the CVS over on Crown Lake Boulevard. Every time you drive in there, there's a semi there unloading beer or whatever, and there's absolutely no provision. Here's a brand new building, less than, 5, 6, 8 years, 10 years old maybe. But it's a brand new building. It's been designed, been approved, and the little thing that has been an oversight is some provision for
Actually, that was prior to our involvement, but there is a loading space. It's just not used.
Okay. But I see that all over town. Now, the interesting thing the other day, up on Old 41, there is a supermarket across from Buffalo Chips. And honest, I'm telling it like it is.
I was going.
The semi stops in the middle of Old 41.
Yes, he does.
And turns on these flashers and unloads right in the middle of Old 41.
He does it every day.
Does it every day.
That's his parking place.
And I look at it and I think, how could and that's a relatively new building, how could that be built and not have some provision for?
That one, actually, I can state as the driver because I can tell you I personally spent hours with our department's engineer going through plans to make sure that you could get a delivery truck into and out of that site. Because numerous revisions to the plans either didn't address it entirely or were inadequate. But finally, we came up with a plan. It is physically possible to get a truck into and out of that site. If
A semi without
yes,
using a crane?
Yes, sir.
Well, is this something that we need to be thinking about, especially for new construction? Because in old construction on 50-foot lot, you do not have any choice. You're whatever you've got, you're thankful you have it. But in new construction, I'm wondering if we should have a little bit more emphasis on
Unloading?
On supply vehicles and so forth.
We do have standards in place, and in fact, several of the commercial developments we've recently approved, you'll see how we've tried to work with them on the location of it so that not only is it in existence, but it's also in a location that's usable. So it has been a focus. If you would like, we can go back and revise the standards as to type, size, location of any type of a loading
All right,
space.
while we're thinking the same thought, we go one step further. Down through the 25 years I've been in business on Old 41, the refuge removal truck or garbage truck, whatever it is, has gone from a little 1.5-ton thing to this monster that's 30 feet long with the hoops on the front and so on. I see these guys are really experts in getting in and out of a 50-foot lot and dumping a dumpster without putting it down on somebody's roof. Right. I mean, it's really a problem because those trucks are getting bigger, and as we get more condensed, there's less and less space for them to operate in, and I don't know that is something that we're considering on the get-go.
It is. It is. You're going to see some of those regulations come forward in the future. And they'll be associated with Old 41, downtown, whatever name you would like to use for it. But consideration for not only garbage trucks, but other uses, access, those are all going to be included.
All right. That's it.
Okay. Do we want to? You want to go any more on this, or are we going to get to that later?
That's not under this.
Okay.
John?
Yes, sir.
Couldn't Audrey, or you said that if the when the city by special exception or general approval by public hearing grants approval for a parking lot, that if something happens to where that lot becomes not capable of handling the number of cars and vehicles that want to park in it, that actually there's a process where it has to come back through to be reviewed by you all.
Yes, sir. It's a pretty general condition.
yeah.
There's not a lot in it, but
Yeah,
it does
right.
exist.
But why can't we put that in this thing on the co-op parking lot for the administrative approval? So if the city goes along with city council of making that administrative approval, that you've at least got the authority that if the tenant mix that's using that co-op parking lot changes to where it's putting that lot in a stress and you're getting people parking other places, that you can bring them back in and renegotiate or whatever.
I don't think you need to have that for administrative authority, because I think it's already falls within his authority. First of all, in 4-2018, subsection 5, any violation of the agreement for joint use of off-street will be grounds for revocation.
Okay.
1. And 2, we have conditions that we have done. I believe the most recent was the one done at the storage facility, where if there is, thank you, great spacing. If great spacing doesn't have good spacing in the parking, it can be brought back to council, for revocation, and where they have to go and do a redesign. So we have language like that we normally do.
Last comment. The thing about the signs on the property for the notice, I think that works with one big notable exception. Somebody comes in and applies in the summer, there's a good chance that most of those surrounding owners are snowbirds. They may not be around.
Not fair to,
Nothing's perfect.
and we're worried about compatibility for people who are not here.
Yeah,
It's not fair either.
yeah.
Correct. Okay.
I got a comment.
We've not worn the ink off this yet? Okay.
And I need to point out, there are, even in neighborhoods where there are a lot of snowbirds, there are people that live year-round. And if
That
they
watch.
believe a neighbor needs to know about stuff, I
Right.
can assure you, certainly in my community where we have a lot of seasonal residents,
Okay.
they'll let those folks know.
Okay.
Mr. Chairman, on page 10 of 17, on the bottom of the placement of street numbers, it requires 3 inches high on any mailbox.
A different ordinance. We're not in that one yet.
Sorry about that.
We're not in that ordinance yet.
Okay.
Wake
so-
me up when it's time.
Deal.
All right. Any other comments on this?
Do we have
Need a motion?
a motion as, could we, I'm asking a question first. Can we make a motion to approve it as amended here today?
Certainly.
Yeah.
And let me just put down what I'm going to tell council with the amendment, so it helps me repeat things. We're changing 4-204 to add that the applicant has to post signs, and I'm not reading the whole text, of administrative approval of certain intense uses. Community development will come up with those uses to council, and council will pick from that list, so that we're not requiring a 14-day
Okay.
on everything. Home occupational permit. You cannot work in your house for 14 days till you post a sign out. We're modifying 4-1352 to remove the berm, and we're modifying 4-1353 because we're deleting canopies and accent bending.
I would make a motion that we
else?
accept this as refined.
Second.
With refinements.
We have a motion and a second.
Second.
Okay, we have that. Any other comments? All in favor?
Aye.
Aye. Opposed? So moved. Okay.
Food vendor.
Well, let's see. Okay. Item B, mobile food vendors.
How did that get B and not pods? I know, that's, okay. Oh, that's right, thank you. Alexis, your turn. At this time, I will tell you, from a legal standpoint, all we have done is adopted a resolution declaring an intent of zoning in progress for mobile food vendors. We do not have an ordinance draft other than the language that's attached to the resolution at this time. It has not been thoroughly reviewed or vetted by legal counsel, meaning I haven't even read it yet fully. And so you're seeing it now, and you will see it when it gets closer to a final draft for permission to advertise and to come before you.
So all today we're doing is just input?
Absolutely. Well, input all the time.
Why is it come to us?
Well, I think we want you to see things earlier rather than later. So it was added to the agenda because it is something that we have a zoning in progress for 90 days. It's not a full-blown moratorium. So I need to have anything from you. You know, if we're going in the right direction or not going in the right direction, your input is valuable to council.
Which section of the Land Development Code
It would be under, yeah.
I think I will be putting
Chapter
it in
4.
the temporary use permit area.
and use?
Yeah.
How is that permit going to originate? Is John going to issue that, or
As
how
far
is
as
this permit for a food vendor?
it would be something that community development would process the permitting under this mechanism, and they would have to fall under the conditions of this permit requirement. And Alexis Crespo is here and can explain the permit requirements.
Good morning. Alexis Crespo with Waldrop Engineering.
Morning.
I have prepared a PowerPoint presentation to walk you through the draft supplementary regulations for the benefit of you as well as the public, and can answer those questions you mentioned. Next slide. When developing these, we did rely on research from approximately 25 jurisdictions. The majority of those are in the state of Florida, but we did reach out to other jurisdictions across the country that have had a lengthier history of the mobile food vending programs. The purpose and intent of these supplementary regulations are to balance the entrepreneurial opportunities offered by mobile food vending, but also balance that with the city's economic development initiatives, particularly for Old 41 downtown, and address that in a broader scope. Also to prevent the proliferation of uses. I have heard some commentary on that specific comment, and proliferation of uses, it's not to say that there is an oversupply of this type of use currently. However, based on our research, it's very clear that these things it's a trend right now across the country, and that they can pop up fairly quickly due to low startup costs. And some quantitative data for that is taken from St. Louis, Missouri, where they had 0 mobile food vendor permits issued in 2010, and as of 2012, they have 29 in place. So these can spring up quite quickly, and we want to be on the front end of it to make sure we're regulating it appropriately at the time being. We also have developed design standards, locational criteria to protect the view sheds from the public, as well as address public health, safety, and welfare, certainly when food service is involved. Next slide, please. There are existing permits, as you know. What is being proposed, the language does not address Nosh truck and the other speakers you heard today. We specifically left that out of these regulations for the time being, as city staff needs to work with those existing business owners to see what's going to be the most equitable solution to address those existing permitted uses. So that's not a part of the discussion today. Currently, your regulations call for mobile food vendors as a non-store retailer group 3. There are no supplementary regulations in place for this use, and they have been permitted via a home occupation license for the most part. There have been other mechanisms done, I believe, for others, but I have not been involved in, obviously, providing those permits, but that was my understanding based on staff's direction. And for vending at special events, that would go through the special event permit temporary use process. So what we have before you today are proposed definitions for the uses, a more clear permitting process specific to this type of use, general design standards, locational criteria, and also address a more flexible environment for mobile food vendors at special events. The definitions, which I believe are on page 1 of your 6-page document, fairly straightforward in nature. They do define the push carts, which are a non-motorized type of mobile food vehicle. Thank you. And then also we have a definition for the mobile food vehicle, which are non-self-propelled. I will be making some modifications to that definition to address trailers, because certainly those are a type of mobile food vendor that's in place. So that will need to be broadened. And I also will be making a revision because all of the vehicles and trailers are not entirely self-sufficient. You have some that have potable water power within the vehicle, and then others do report to commissaries for those types of services. So that will need to be broadened. Currently, the definition of commissary has been taken straight from your Florida statutes. There has been some changes within the last month or so that we'll need to look at in terms of how commissaries are defined, and so we'll be looking at updating that as well. And then lastly, definitions for vendor and permit. So the first item is permit required. We have created a mobile food vendor permit for these uses to replace the home occupation license process. And basically this section indicates that there's a limit of 5 permits citywide on a first come, first served basis at the time being. I'll reiterate this throughout the presentation that this is a starting point. We believe this is appropriate based on the current status of economic development efforts today, but this is certainly going to need to be reevaluated regularly based on how those economic development programs progress over time. So this is, again, a starting point. And in light of the minimal number of permits that would be issued citywide, we are allowing the permit holder to be approved at 2 locations. Many jurisdictions have a maximum of, let's say, 15 permits or 20 permits citywide, and one vendor would have to get a permit per location. So this would allow a vendor to have 1 permit, which would allow them to go to multiple locations.
On the limit of 5 permits citywide, do the individuals that are currently vending have first choice, or are they automatically included in that 5?
That is part of that to be determined area based on discussions directly with city staff. So I have not been involved in those to date, but that will certainly be something that needs to be addressed and expanded upon in this document as we move forward. And then the permit is valid for initial 6-month period, and then they'll be able to extend that for a year following that, 30 days prior to the permit expiration. So based on our research of other jurisdictions, this is fairly lenient compared to other jurisdictions, which, you know, sometimes it's as minimal as 2 weeks per permit. We have a section on application requirements, the first being a photo of the vehicle or cart to make sure staff is reviewing it, to make sure it's attractive, aesthetically pleasing, and not overly dilapidated. Site plan will be required so that we are aware of those permitted location, again, a maximum of 2, so they can be identified when they're in use. The location where that cart would be stored when not in use. Copy of all local and state permits that are required, and a copy of the commissary agreement where applicable. And again, those self-sufficient types of vehicles would not require a commissary agreement.
Do we ask questions now or when you're over?
I think it's fine to ask now if that's what's most comfortable.
Some of the facilities will have food prepared someplace else.
Correct.
And as I understand the requirements, it cannot be prepared at home. It has to be prepared in a licensed kitchen.
Correct.
So my question comes up is how is that supervised?
The state licenses those type. They determine whether a commissary is required or whether it's deemed to be self-sufficient and can prove it provides all the necessary requirements to prepare the food within the vehicle.
Does the state issue that permit?
Correct. Yes, they do.
So the state would issue a permit whether it can be prepared on site in the vehicle or has to be prepared in an improved kitchen someplace else.
Correct. And then the city would verify, and as part of the application process, those permits would be provided to staff so they had the comfort of knowing that information, so they were aware of it as well.
Okay, thank you.
Thank you. Another application requirement is an affidavit from the property owner where the vehicle or cart would be parked, making sure that that property owner is aware of these supplementary regulations and the various amenities they need to provide the mobile food vendor, which one of them is access to restrooms and access to refuse facilities. And this is very common in most of the ordinance we reviewed, where most jurisdictions are requiring access to bathrooms, whether it be on the lot, whether it be within 20 feet of the mobile food vending truck, but to provide that facility for patrons.
Is a portalet gonna fulfill that requirement?
This was written specifically to prohibit portalets popping up next to the food vendor. And that will come later when we get into the locational criteria. But touching on that, you would have to be on an improved site with an operational principal use, so that you're in a parking lot of an existing business, and that business owner signs an agreement that your patrons can use the restrooms there if necessary.
Okay.
Is
To
there
avoid
a
the-
provision in this proposed ordinance to where the fire marshal looks at this proposal and all that?
I don't believe
They believe on all permits, they do look at it, so it would be no different than their normal course of business.
I think it ought to be written in there, because especially the ones that pop up and are only around for a week or two.
Something similar to what I have in the other ordinance, that nothing in this code can precede the life safety or the building code.
Right.
For the record,
Doesn't
Jennifer
mean that it
Dufala
won't-
Hagan.
All I want to make sure is that they get a chance to look at it, that's all.
Staff, again, for the record, Jennifer Dufala Hagan, Community Development Department is working in partnership with Fire Department to review all of these applications currently that have come in the past and moving forward. We look at reviewing not only the site, but also the safety of the vehicle, and Fire is particularly interested in gas or any kind of combustible product that would be on or part of the carts. So that would be part of the review.
That's good. Okay.
I have a little question here. We'll talk about access to restrooms. This can get way out in left field, because when I just started selling ice cream, I had to put in a handicap bathroom. And so I'm saying this could get ridiculous here. Would the restroom have to be handicapped for a hot dog stand, for God's sakes? That's ridiculous.
It's currently written if the restrooms in the principal use were meeting your code requirements for their restroom facilities. This would not require any upgrade to those facilities. It would just need to be provided. So I assume most facilities would have both the handicap and
Well, I think if it's open to the public, it has to meet the handicap
That's not a
requirements.
zoning condition, that's an ADA condition,
And
and
so,
we
you
can't
know,
waive ADA.
once we're blowing something into a huge
Yeah, how would you
deal here.
How would you address an empty lot? If I'm vending on an empty lot, how do I get a restroom there?
this proposed regulations would prohibit a mobile food vendor from locating on a vacant lot.
That's
That,
ridiculous.
again, is
Wouldn't that
coming
be
later.
an opportune situation to be on a vacant lot?
There are many different camps of thought on that topic. Specifically, in the old 41 downtown, the thought and direction from the city manager's office was that the primary goal in terms of economic development is for infill permanent redevelopment on those sites, and that these types of businesses need certain facilities, waste collection, restrooms for patrons, adequate parking, things of that nature. So that the intent is to kind of bring them up to more of a fair playing field with some of the other brick and mortar establishments.
I hear what you're saying, but on the other hand, the new hot dog place next to my place on Old 41, that lot's been empty for 10 years, and these gentlemen put in a beautiful installation there with paving and fence, and it's just as cute as can be, and I think it's quite an asset to our community instead of having an empty lot there. That's and so I think that we're going in a direction here where we're discouraging rather than encouraging improvements. And I realize it's a temporary thing. It's not a brick and mortar thing, but yet it is an improvement over an empty lot, and it does bring business downtown. And I think we need to do everything we can to make it as simple as possible for these people to operate in a legal, healthful manner.
It seems to me, Rex, it's a question of do we want this sort of thing or we not? Because it is discouraging to those who are looking for an inexpensive way to conduct business, and some of them can be pretty attractive. So the requirement of a restroom is is pretty stiff. Pretty stiff. So you're sort of saying that, well, you're going to have to be associated with a building to be here.
Correct,
And
and
that-
operational.
that's gonna-
Sam, the other thing is, once we put in a restroom, then I'm telling you, I'll guarantee that the thing is gonna have to meet handicap, if
Well-
the public is gonna use it.
Architecturally, I probably wouldn't approve it as a
So,
freestanding building.
You know, all once now,
Nice ones in
we've
Paris.
built a huge hurdle here, which,
Again, the intent here is not to require the principal operational use to have to upgrade their bathrooms beyond what the ADA requirements are. I believe if they are in compliance and provide the number of restrooms per their square footage, we're not asking them to provide additional. It would just be to allow the patrons of the food truck to use their facilities. But certainly, this is our first run at this, so we can incorporate
Yeah, I
these
think that's going to
concepts.
be really, I mean, the refuse collection is one thing. I mean, everybody can have a couple of trash cans and take them with them. That's fine. But, the restroom thing, I mean,
I guess,
isn't the intent of these mobile vendors to afford the public a quick stop in to grab, to get a hot dog or a taco or whatever it is that they're making and then just motor on their way?
let me ask a question of Alexis, as well as staff. Have you looked at the old 41 section of the comp plan, as well as the comp plan in general, to determine whether this is consistent or inconsistent, the process that we're proceeding with at this point?
There's certainly, in terms of the LDC requirements for Old 41, would require additional changes to that.
Okay, but have you looked at the comp plan? I mean, these folks are looking at things for consistency with the comprehensive plan. So the question I'm asking is, have you looked at the comprehensive plan to see if there are goals, objectives, and policies that are consistent or inconsistent with the proposed?
Not to date, no. This is,
Jacqueline Genson, I think the comp plan's very general in nature because it promotes the walk to town feel, walkable neighborhood. So it doesn't really get into the detail of mobile.
I mean, I think
food
that's something that staff also needs to do at this juncture to make sure whatever we propose to LPA is consistent with the comprehensive plan. Even, and I agree with you, it is a very general term. There's pros and cons of how to interpret each policy.
Well, where you have this type of vending, cities offer public restrooms. And that's typically the way that's taken care of. If I'm in New York, for example, I go to a hot dog vendor, I've got a public restroom that I can use that's probably nearby. So the onus is not on the owner of the vending stand, but one of the cities. So that requirement seems to me would fall to the city to provide those types of facilities. Those are my thoughts.
For the record, Jennifer Dufala-Hagan, staff did look at some of the things that have been proposed for the Old 41 area since the city was incorporated. Part of the amendments to the comprehensive plan amendment that included the Old 41 overlay did speak in regards to mobile vending kiosks and temporary type uses that would enhance and contribute to the pedestrian connectivity of the Old 41 area. So again, it is very sparse as far as what was suggested, but there is backup there that could attest to those being types of uses if council and the boards would recommend that type of consistency.
you're exactly right. And when we were doing the Bamboo Village project down there was a wide walkway, and it was designed specifically for various vendors to be there. And so I think the theme of the Old 41 overlay has been a casual type shopping area that this would fit into very well, and I think it's important to us to keep the goal in mind to make those things be able to happen without insurmountable problems.
and just speaking from the direction received from the city when drafting these, the thought was to be able to implement and get farther down the road in that pedestrian-friendly, vibrant downtown. In most cases where you have a really strong mobile food vendor, cities that really promote and are looking to add these, there is a existing, thriving, pedestrian-oriented downtown. And the thought was, let's try to get closer to that before really allowing these to move in and expand, which can happen somewhat rapidly. So that was the thought process. We certainly acknowledge your comments, and It's a chicken and egg thing. Can this spark that, or will mobile vendors hurt the brick and mortar that are just trying to get going down there? So that's really, again, the two camps of thought on this.
I appreciate what you're saying there, but with a limit of 5 in the Old 41 area, I don't think that we would be overwhelming.
And I don't think you're going to like this, but in about 2 slides, I'm going to get to where mobile food vending is prohibited in the Old 41 downtown district currently being proposed. So this would be permitted within the zoning districts, which allow for your non-retailers group 3. But what is proposed is for current time, new, at least mobile food vendors would be permitted within the downtown area, which seems to be very contrary to the desire of the LPA, from what I'm hearing.
It appears, though, that you have some restrictions here for the time limit that they can be there, right? 6 months and then a year, at which time anyone that wants to buy empty property, for example, would have time to negotiate and work out something in that time frame to put a brick and mortar building there. So you do have some requirements that will allow a limited use of that property, right?
Correct, yes.
Mr. Chairman,
Go ahead.
in terms of these mobile vendors, would you prognosticate that? Would you prognosticate that the vendors would most likely be located near or adjacent to the city park?
Not necessarily, no, because
My thought about that was you do have permanent facilities in the
Yes.
city park.
Yeah.
Yeah.
Okay.
Yeah, I don't think they're accessible when there's not an event.
I mean, that could be handled.
Yeah.
Question, Mr.
Okay.
Chairman.
Yes.
Speaking of the park, Riverside Park, there's a lot of nonprofit events that take place there with vending carts. Would they be exempt from this, or would they have to go through the same procedure?
We actually have a special event permit. They could go, special event, this is not applicable to special event permits. So
Well, it is addressed later in the
Right.
regulations.
Right.
But it's much more flexible for special events than it
Okay,
is
thank
for
Yep.
the permanent ones.
Okay.
Question, so the thrust of this would be, you could get a permit to put one of these, let's say a vending trailer on a site, and it would start out for 6 months and it would get extended, you could get it extended a year, and then at the end of that, then they have to go to brick and mortar, is that what you're
No, they
saying?
would renew their permit.
Or renew
They
the
can
permit?
continuously renew the permit.
Okay. Let's go ahead.
So just finishing up with the application requirements, we have an insurance requirement, which we felt was middle of the road compared to your Tallahassee, which requires $1 million worth of insurance, and other jurisdictions, which are more around $200,000 to $300,000. So we're proposing a $500,000 insurance requirement.
Right.
And then lastly, letters of no objections from abutting property owners. A lot of different jurisdictions handled this differently, with a petition of having at least 80% approval from owners 1,000 feet from the property, which seemed overly conservative there. So we're just requesting that the abutting property owners provide a letter of no objection. Getting into the general standards, we're not proposing any changes to your zoning districts in terms of where the non-store retailers group 3 mobile food vendors can be located. They're currently located within your C1A, C1, C2, CC, light and general industrial, and your CPD, IPD, and MPD. So no changes there. As we mentioned, this is proposing that they would be located on an improved property with the operational principal use, and the hours of operation are proposed 8 a.m. to 9 p.m. unless through a special event permit. The other standards include a 3-day maximum duration at the same location, so they would need to move from that location after 3 days' time within a 1 week time frame. So we would assume that most mobile food vendors would get 2 locations approved and be able to move, because these are really intended to be mobile in nature. So to have them park continuously in the same spot really becomes more of a food stand type use than a mobile food vendor. And I'll tell you, New Orleans allows mobile food vendors to stay in the same place for 45 minutes at a time. So this is fairly lenient when compared to state and national standards for locating these uses. One item that was added, which was not originally proposed, was conformance with the city color palette. There are other ways of dealing with making sure that the mobile food carts are attractive and pleasing to the eye, which could be, you know, limiting neon colors and things of that nature. But as currently proposed, per direction from the city, we're looking at compliance with the city color palette. No blocking rights of way or driveways, and the principal use would need to demonstrate that there are additional parking spaces available to support the mobile food vendor, which would require 3 spaces per vendor. Setbacks would be in accordance with the zoning district regulations. I mentioned the parking spaces requirement, no alcohol sales, no amplified music, and no discharging of waste or wastewater on the site. Prohibited locations, we've kind of already addressed this. Prohibited in residential zoning districts, I think is pretty standard and understandable. We are proposing prohibition in downtown Old 41 district, which may go a different direction upon your recommendation. 1 vendor per lot or parcel to, again, prevent proliferation or concentration of the use. Proposing to locate 500 feet from church, schools, or other restaurants, and 2,500 feet from other mobile food vendors. Special events, there would be no maximum number of vendors permitted at a special event. There would be no limitation on their location, so they could be clustered together. They wouldn't have to meet any of those separation requirements. And whereas the temporary use permits are typically 3 days, they could administratively be extended for a 10-day maximum based on the type of event. So to conclude, what we're proposing is an entirely administrative permitting process, which is currently how you handle it today. We're looking to comply with some of the broader economic development directives of the city, prevent proliferation,
What's
allow...
that mean?
I beg your pardon?
What does that mean?
Proliferation
Lots of the vehicles coming.
would mean going
More and more of
5
them.
limit.
would mean from going from 4 in 1 year to 16 the next year. Allowing for increased flexibility at special events. And lastly, again, this would need to be reevaluated as the economic goals are being implemented in the downtown district. So that concludes my presentation.
Okay. I got a couple questions. What, Audrey, you
I
have
have
something?
a question. It was something because triggered by what you said, and that is difference between a mobile food vendor and a food stand. But we don't have a definition in the food stand, and the food stands are the ones that are more at a fixed location and stationary is the way I'm understanding. Are we regulating them differently, or?
At current time, they are not included in these supplementary regulations. So
Okay, because the businesses that are existing, the ones that have gone and obtained permits, whether it's a temporary use permit, whether they went and got electrical, grease traps, everything else, that sounds like we need a definition for a food stand that's different than a mobile food vendor if they're doing stationary development order type activities.
I agree.
I have 2 problems, if you can go back a little ways. The 3-day thing, well, prohibited in downtown Old 41. If there was ever an ideal location, that's where it is. I mean, you have fairly low speeds. You're supposed to anyway. There's a decent amount of traffic there. You can't. Where would you put it? I mean, you can't put it on US 41, the beach road. You'd get crushed. I mean, would seem to me that that's almost an ideal location. I mean, like Rex said, here we had an empty lot that lot's been vacant for almost 10 years, and now we have and it's pretty spiffy looking vendors sitting there. So the 41 and the 3-day thing, I don't understand how we can. So this guy's got to move every 3 days. I don't know.
Do you have a recommendation on the maximum duration that?
Well,
would he take his restroom with him?
There you go.
And again, this is not intended for the hot dog stand, which is a very different situation than really the typical mobile food vendor we're talking about here. Well, the difference is they've gone through a development order process and made improvements to the site, whereas we're talking about a food truck that pulls up to serve lunch and then would pull away in the evening time and wouldn't be stationary as they've set it up to be.
Currently, we have on the books commercial use of rights of way where it is prohibited in our right-of-way. So you can't just pull off the street.
Exactly.
And set up. So we've always regulated that prior to the city's corporate existence. This is the next level, going onto people's property, where they get the permission from the property owner.
Exactly.
As opposed to just pulling up in front of places. So this is the area where we're trying to regulate at this point.
And staff would also review, upon receipt of a site approval for all of these vendors as part of their permit process, where they would be located and operating out of any commercial location. So they are required certain parking spots. They would be looked at for any kind of public safety issues and stationed in the appropriate area within a shopping complex.
So Jennifer, you would, the last one there, you can't park in the principal uses for required spaces, but there's a requirement for 3 parking spaces.
Correct.
So-
And let me give an example. If you're familiar with the big shopping lot that used to be the art frame store where the Fig Bistro is
Yes.
now on US 41, that has a very large parking lot with an exceptional amount of parking
Right.
spaces. So that would be an ideal location for somebody to operate out of that would not affect any of the required parking spaces for the operating businesses, but be far off of US 41. When Lee County permitted these in the past, they used almost a 250 foot kind of idea of off of any right-of-way for these types of vendors. And that was just a guideline that they looked at, and that was a specific guideline that doesn't necessarily apply to what we're talking about. But staff would look at public safety for site selection for these vendors.
Have you looked at the differences between the vendors that would be in large parking lots on Tamiami Trail and the ones that would be downtown?
Well, again, this amended language that's going in front of you is prohibiting vendors downtown. So staff was operating out of the direction of these amendments. So we're here to have that discussion with you.
Yeah, if you are vending in a large parking lot, say on Tamiami Trail there, have you looked into what success these vendors have in locating in those large parking lots, in large shopping centers? I mean, is that something a business person would do?
I can speak with my own opinions,
Sure.
But that's not something staff looked at as far as this amendment goes.
Because it's a business deal, and I'm wondering, if I'm tucked back into a shopping center, can I make a go of it there?
I think the only one that's ever done that is the guy that's at Home Depot.
That's right.
Right, and those are different.
And that's because,
uses.
he's parked by the exit to that building, so you have to walk by him. But yes, he does. But I mean, as far as anybody seeing him from the road, that's not going to happen.
And
So-
that use is considered to be accessory to the principal
Right,
use.
right.
So that vendor is there to sell hot dogs to the people attending Home Depot for another
Right.
type of purchase.
Right.
So from a planning perspective, these type of vendors obviously are more successful at a denser, more pedestrian-oriented area. They do very well, as we know, in farmers markets, and those are very densely populated areas with lots of traffic and walkability. But we have not done studies on.
Well, that's what I'm looking at is, as we apply the restrictions here across the board, how does it relate to the different type of vendors that we have, and what is appropriate, for those type vendors from a planning standpoint? That to me would be my concern, is that the regulations are appropriate for that particular use in that particular place.
We did not have in our packet this layout here, so we're seeing this for the first time, and some of the things on there come as quite a surprise to me. I thought our motive was a different direction than what these standards are taking us, so I'm a little confused on what our direction should be here in relationship to this, because we don't have this in front of us to.
I just
And
have,
most
I
of
picked
these
one that was
items are
in the
just pulled
package
from
today.
your 6-page draft language. These are just highlights from that
Right.
document.
So we're just vetting through this, right?
Yes,
now.
and at this point, because we have a zoning in progress, staff has been ordered not to issue any additional permits during the 90 days while we try to formulate. We're trying to get an early handle of what we should formulate. We have what Ms. Crespo has worked on and with the philosophy set up. The final product may be significantly different depending on staff discussion, policy considerations by both the LPA and city council as it goes through the public hearing process.
One thing that we're looking at, someone who's sitting still. I look at the ice cream truck that runs around town. How does that fit in?
That's
to
different.
Piece?
And actually, I need to look that up. The ice cream truck is purely mobile. I know that they're under Florida Uniform Traffic Control Law. They need to have like signs that say that they're going to be, they stop so that you don't have, I know, you're laughing at me. Let me look at commercial use of rights of way because we do have.
While you're looking that up, would it be appropriate for me to ask a question of the people that have that set up on Old 41 across from the fire station? Can I ask them?
Sure.
There's someone here from that? How is that unit there every day, 7 days a week? Yes, sir. And it does it leave?
To the microphone
Come
so
on
we
up.
can get it on the record.
Introduce yourself. Yes.
And your name, please?
Speak right in the mic, please.
Thank you. I'm Phil Pugh. I own the property.
Okay.
And my tenant, Rick Price, it's his cart. He's open 6 days a week currently.
Okay.
He has the option of being open later than he's was it 10 to 5? 11 to 5. He has tried some evenings. It has not been financially successful.
Okay. Does he take the unit with him at an evening, or does it sit there?
He can for special events, but he has been leaving it there.
Okay. All right. Those are my questions. Thank you.
Thank you.
Appreciate that.
Mr. Chairman, you're looking for comments on this?
Sure.
I think this is, the effect of this is going to be to eliminate any vendors in the Old 41. And I don't understand why the council wants to do that. I can understand the regulations of it, although if you go to contact people how many feet away from you to get their permission,
Right.
I think
that's
it's in
there.
effect just prohibiting it.
Because I have the two problems I have are the 3-day maximum thing, and I.
Yeah.
At the risk of making it seem like it's a permanent installation, which it is not, my feeling on that part is that it should be based on the permit duration, and if there's a problem, whatever type of problem comes up, then that would be voiced with the permitting authority, and at that point, I mean, they could either not renew it or something else, but I think we're beating up something that doesn't need to be beaten. I think the intent of these units was, I think it's great. I think it looks, like I said, that lot hasn't looked like that in a long time. It looks really nice. That's just my
I do
opinion.
too. And having a 2,500-foot separation between portable vendors, that's about a half a mile. And I think that's a bit excessive because you have to be successful, I think you have to be where the people are. And the people are concentrated in a certain area, then that's where the food vendors want to be, have to be in order to survive financially. So I'd strike the 2,500-foot separation. The other problem that I have really, someplace, if you're selling a product that is prepared someplace else, it has to be in a licensed kitchen. And we had a problem with the caterer several years ago about his kitchen was in Collier County, and he was a caterer in Bonita Springs type thing. And so I'm not sure how the relationship between the approved kitchen and the food vendor is stabilized. That's one question. The second question I have is, once you start to cook something, Bonita Springs Utilities gets very, very interested, and they have these huge requirements about, I put in a $5,000 manhole to sell ice cream. I really did. The manhole cost $5,000, and it was so I could sell ice cream cone. But they get real excited about grease traps, which I guess now you can't have above ground one, you got to have a below ground. So I can see an area here that is, if I was a restaurant, or if I was a place that sold food product and I had to put in a $10,000 grease trap and manhole thing, and the guy across the street can pull up in a trailer and not do anything, I would have some concerns about that. So I think we need to think this thing out a little bit quicker. And my other question is, the only place in town I can think where these would be successful would be in the old 41 overlay area. I cannot visualize these being in a parking lot out on 41. If I was investing money in it, it would be a guaranteed loser out there. You got to be where people are. And so I think we need to review the uses here substantially and the overall picture. We had Mike Bodie come several years ago, and we had an open house one day, and he's got a real slick unit that is completely self-contained. He doesn't need really anything. And I think now that's the kind of thing when you're looking at a 3-day maximum, that can pull in and pull out. But the people down the street across from the fire station, they have done some elaborate landscaping and site preparation work and so forth and so on, and they've got to be there forever to recover their costs. So I think we're beating a dead horse to death here, and this is the kind of things we need to make Bonita Springs unique and cute.
Well, Rex, that's why I asked a question earlier whether or not the community development looked at from a planning and business side to this as to what effect it has. I think you're right that as a businessman, and I think that's what I've been hearing here as a business, this is not conducive to conducting a business in the old 41 area, and I'm wondering what the real intent and the direction is that we're looking at.
I think Ms. Hunter might be able to talk about the current status of Old 41 and the position taken by staff as to
Sure,
the
that's what I'd
redevelopment
like to hear.
efforts.
Good afternoon. For the record, Arlene Hunter, Director of Development Services. Some of this, is to give you a little bit of background, is there are some businesses that are currently in the old 41 that have had concerns about the vacant properties that we have and the redevelopment and putting brick and mortar on those redevelopment. And we realize that the economy of the downtown is in a fragile state, as you all well have known. It's studying it as well, and the council's making some significant changes. We've had staff direction to begin a CRA to look at a centralized stormwater system, to look at on-street parking, and to look at those improvements that need to be made so that there is an easier way for those folks to come in and develop these vacant buildings and vacant parcels more easily. The statement that Ms. Crespo made is that there is a concern that when you have a few of these vendors in, they can proliferate, they can multiply very quickly. There's evidence of that in many downtowns. As you might see, the ultimate goal would be to develop the downtown so that these mobile food vendors could be part of a thriving business. A thriving office could be there with an adjacent food cart where those tenants of the office come down and grab their lunch. A lot of these mobile food vending are successful in downtowns, but usually the downtown is more developed, and so folks are traveling into work for the day, into their city. They may not necessarily want to move their vehicle because of parking, because of a thriving downtown. So they get out, they walk around, they grab their lunch, may sit in the park and enjoy their lunch, and then walk back to their office. We think there is a future need for the mobile food carts, but with the state of the downtown as right now, we're trying to develop that area with brick and mortar buildings and filling in the vacant space that we have. The idea too is the example of the Home Depot where there is a cart, there is a food cart right there. People are going in to use the Home Depot. They're coming out and buying a hot dog and getting in their truck or their car and going home. So the mobile food vendor is actually an accessory use to an existing building.
Can I ask, is it I saw one of the requirements here that you must have, as a vendor, you must have an agreement with the lot owner. If you have an agreement with the lot owner, shouldn't it state that if I have a buyer for my property, then your lease is up as a vendor? Would that not happen?
I think that would be the lot owners.
Well, that's what I mean, is that
No,
it's
that's up to him.
vacant because nobody wants to buy it. And there are reasons for that, but if I have a vendor on it and he's paying me some rent, I can at least collect something while I'm waiting for the buyer.
I think that might be, as the chairman said, a contract negotiation between the
Right.
tenant and the leasee. But the other item that we have in the proposed language was that each year the
Right.
tenant would have to resubmit. So you wouldn't necessarily be signing a 5-year lease. Whereas
correct.
if the owner had somebody who
correct.
could come in who wanted to actually develop the property, they wouldn't need to wait 5 years till the lease was or go
Right,
through
that's
a
what I would think, is that
contractual
if he has a
obligation.
buyer for the lot, then that almost negates that agreement right there.
And I think the proliferation concern is addressed with the limit of 5. I mean, that's,
Right.
I don't know where that number came from, but it seems very workable for that area.
Currently, so you realize there is no limit on the number that could be there.
Okay.
There's also, we just also want to make sure and I know many of you know, we went through a very extensive dumpster enclosure process. So we want to make sure that our refuse container is attractive and that it's not a nuisance. And so many of the businesses downtown are working to conform with that because of sometimes there's lot spaces and the space of the business. It's difficult to fit that in, but people are working forward to do that. We want to make sure there's no trash left on these properties as well. So if you're with an existing business, there's already a dumpster enclosure or a garbage enclosure that's there, so that they have part of that agreement. They can just put the waste into that existing business's trash. That'd be part of their agreement.
Okay.
So there is an additional refuse that have to be set up.
Anything else on this, gentlemen?
Mr. Chairman, if I may speak in reference to some of the questions that Mr. Sims had in regards to the grease trap and some of the other requirements. Just so you know, this language was drafted through Ms. Crispo in partnership with staff. Community Development is working in partnership with her in regards to site selection and the zoning process that would accompany any of these amendments that we're going through the process right now. But I think we do need to look at a definition of possibly a food stand versus a mobile vendor. I know right now in our old 41 permitted use groups that you can have currently, it says restaurant or specialty food establishment. Also, kiosks and push carts are listed as those permitted uses. So we really need to look at the definition of those different items and what is entailed with those. For instance, Mr. Sims spoke of the grease traps requirements. That's something that community development is working with applicants on. If any restaurant comes in, a brand new restaurant, regardless of where they're going to be in the city, a grease trap may or may not be required as part of their business plan based on what they're looking to sell. So one of our applicants that's currently vending on Old 41, Phil Pugh's site, did go through the added expense of adding a grease trap. That was something that he did in partnership with Bonita Springs Utilities, and it was permitted through a trade permit with community development. However, the intent for these mobile vendors is for them to be self-sufficient. The comparison that I could make is of a motorhome. You can have a motorhome that can pull into a site and be self-sufficient based on their generator and their gray tank, their gray sewage, and be self-sufficient for a few days and not have any impact to that site and pull out in 3 days. Let's say, give or take for conversation's sake. We envision, or the intent of these is for a mobile vendor to be that, to be a mobile vendor that comes in, pulls out, does not leave anything on site, and there is no trace, almost goes to the old leave no trace ethics, that would apply to that mobile vendor. If you're looking at a food stand, those requirements would be much tighter, and the investment of that type of infrastructure would be much more of those, almost relative to a new restaurant or a brick and mortar mortar type of operation. So those are the things that we are kind of considering. Again, we really want to look at the synergy and the balance of these types of operations and those that are currently existing throughout the city, and the ones that are looking to locate downtown as an area that, as you know, as we look at developing a CRA, we're going to focus on economic development, providing incentives for business, and we really want to draw anyone, whether they be mobile, whether they be pedestrian, whether they be residential or business, to that area. So we really need to reach a synergy not only in economic development, site selection, but also be business friendly. So those are the things that these types of amendments need to come forward, and we need to just pick apart and make sure it makes sense for our small town Bonita and be on the forefront to actually encompass all of those. So
Okay, it's a work in progress.
Nicely done.
Any other comments on this?
I do know that some of the public wanted to speak at this time on this particular item. If they do, other than Mr. Pugh, this should be the time to allow them.
Okay.
Maybe
Anyone
not.
like to weigh in on this at this point?
You were talked about, so you might as well.
Good morning. My name is Mike Bodie, former food vendor. Thank you for that shameless plug, Rex. I appreciate that.
I didn't know you were out there.
My name is Mike Bodie, and I owned a mobile food vending unit. It was a trailer-type unit, wasn't the self-motorized. And first of all, I want to let you all know that those are not inexpensive. It's not like you could start one for $10,000 or $15,000. When I sold my restaurant after 6 months, I became bored, and my wife and I decided to go into the catering business. By the time we got done with our unit, including permitting and all that goes with it, we spent over $100,000 for that unit. We could move it to any location that we wanted to as long as we were permitted to be there. So it isn't an inexpensive entity. It kept us busy, but not as busy as we would have liked to have been. Our primary goal was to go to special events, but we would have found it wonderful to find, let's call it a home, that when the weekend, when there wasn't a special event, during the weekdays, we could still generate income. And as far as I'm concerned, Old 41 would have been a perfect location for that, for me, for our unit. And I know it's probably doing well for the 2 units that I've seen up there in the past. In regards to what you said, Arlene, that you're trying to go after the brick and mortar establishments, to me, which came first, the chicken or the egg? If someone looks at Old 41 and sees no activity, and they're interested in possibly putting a business there, and there's no activity, they're going to go somewhere else. If we have something like food trucks that may generate some business to become a destination area where people can walk up and down the streets and enjoy Mexican food or Indian food, and even sit at a restaurant that's there, then they see a little vibrancy, they see vitality, and it would make them more apt to go and establish a business there. So I think to not look at the future and to not look at the cultural trend where people are actually taking advantage of food trucks, like the Immokalee Casino. Every 2 or 3 weeks, they have a food truck rally, and thousands of people show up there, and the food trucks come from all over the state. It's a moneymaker, and it also helps the vitality of Immokalee, which is something we should address. We shouldn't avoid, we shouldn't overlook. Thank you.
Thank you, Mike.
I'm Phil Pugh again. I own the property where the current hot dog stand is. Just to tell you a little bit about myself, I've been here quite a long time. I used to drive up Old 41 when it was the 41, up to my business that was on the north end. I bought the old Fort Myers Serpentarium. That's where Bubbles Car Wash is now. But for years, I'd go up 41. Our vehicles were serviced at Smith Garage. We bought commercial gas water here from AmeriGas. We ate at Whistle Stop and Nicholas Keg. I think you guys remember this. But my point is that I'm not trying to put credibility to myself, but to let you know I care. I'm a neighbor. I have history and roots. A few years ago, well, quite a few years ago, I bought the AmeriGas property. We took down the crummy old building. We got rid of the gas tanks. I did environmental surveys and cleaned the land. I had somebody interested to do a restaurant. I'm not a big developer. It's just me. And they were going to do a neat theme restaurant. Well, the bubble burst, and, you know, we didn't do it, like so many things didn't happen. So I sat on the property, I cut the grass, and a year ago I was presented by a food vendor about putting a cart there. I said, that's interesting. I said, you know, let's do it, but if it's all right with the city. And he started. He ran into problems, and I appreciate your business questions, because that's what it comes down to. And the city asked for certain things to be done. He couldn't do it. It was beyond him. So I got interested. I went to New York City, Atlanta, Asheville. I saw the trend for food carts. I said, I like this. So thanks to Jennifer and the encouragement of the staff, we proceeded ahead. I said, I'll do whatever you want. We did. I think I went beyond because I want it cute and charming. I know it's not going to be there forever, but I thought it could be of some value now. I met Rick Price, and I said, Rick, boy, he has a brand new cart. Brand new, immaculate, inspected by the fire department, everybody. I went ahead, we can't move it on, it's a big cart, but he can be out in 45 minutes because there's indirect connections. Well, I even went ahead and put the grease trap in. God bless you, that's not fun. The point being here is that this ordinance would eliminate it. Not only does it say no food carts in downtown, but these line items, and some you don't see, are so restrictive, it would eliminate anybody going down there. Financially, eliminate anybody. Hey, I don't know if food carts really make that much money. I mean, Rick is not setting the world on fire, but each month it's getting a little bit better. And I said, if we're going to do this, let's do it correctly and pretty. This proposal would put us out of business. And what I'm asking is, if you want to do something, please take us out of the picture, because we're permitted, we did everything we asked for. Grandfather us in. If you need to do some type of restrictions, I'm asking for, please, take us out, call us something else. Let me put my salesman hat on. This is more of an attraction. This food cart, food stand, food trailer, brings in hundreds of unique first-time visitors. I mentor some young adults who are in school, and I sent the family to I bought them lunch at the food cart. I sent them there, and Rick took care of it. And they sent me this note. I got to put my glasses on. Phil, thank you for sending us to Hungry Hound Dog and taking care of our lunch. The chili fries were the bomb. I think that's good. We took a 15-minute stroll and discovered a cute flower shop, heavenly scent probably, and a delicious ice cream store, heavenly shaped, I assume. I didn't realize how cute the park was across the street, and the river was beautiful. We also found our new favorite restaurant across the street. I guess that'd be a plug for Ben's Survey Cafe. The point being is that this is the essence for us, my neighbors, to get downtown going. New people. I don't see anything junk going on, and I know this won't last forever. My last point is, I don't think you would want me to build anything right now, because the restrictions of me to build something charming and architecturally cool is not there yet. Specifically, the main thing is water retention, and I'm glad we talked about that today. Setbacks, parking. We're not there yet. You would not want me to put a simple 2,000 square foot t-shirt shop. We're not there yet. And I appreciate you saying that, you know, this lease gives me the opportunity to do something with the property until it happens. I'm sorry, Rick, I won't be there forever. But I like it to stay there until the economics make it happen. I want to let you know who I am and my commitment as a neighbor. I spent probably $16,000 just to get this little stuff done. I know Rick spent some money, but I appreciate your concern to not put us in this group. It's more of an attraction, and I think we're doing a good job. Thank you.
Thank you.
I hired Chuck here because there were so many words to this I didn't understand, and he'd like to say a few things. Thanks.
Could I ask you a question?
Oh, sure.
Based on this ordinance, what they're saying they would allow, give me your reaction to if that got passed and those 5 that meet this came in and you were still there, is that good or bad?
Well, this ordinance eliminates anything in Old District.
Let's assume that they grandfathered you in.
The other things would still, as it stands right now.
Be a good thing for that area to have those other 5 kind of things.
I'm in favor of food carts.
Okay.
And you know, I don't think you need to restrict them. I would like to get with these people if they're in decent carts. There's a lot of property there. I own a third of a block. And I would love to have special events, food cart rallies and Corvette clubs. But eventually I want to have a Fifth Avenue type beautiful building. But for now, and I'm afraid it's going to be several years, that that's not going to happen. But in the meantime, I think we can bring in a lot of good families into town. Did I answer your question?
Wouldn't the 2,500 feet between them restriction?
You're right. It's kind of silly. Of one of the, I think, the silly items on there. I mean, I know what the purpose is. I don't want 40 Old Downtown to go further down. I haven't addressed all those issues. I just know my property and what we're doing. And I'm just asking you to please don't put us in this.
No.
Thank you.
Thank you.
Good morning. Charles Bassinet for the record with Henderson Franklin. I'll make my comments brief. I'm going to ask you gentlemen to read this regulation very carefully. I think what you're going to find is that, at least in its present form, it's very restrictive in nature. I want to stress that in its current form, at least, it prohibits mobile food vendors on Old 41 between Bonita Beach Road and Rosemary. The 5-cart limit is for the entire city. It's not for the Old 41 area. The Old 41 area doesn't allow them at all. I agree with you that in point of fact, the best place that you have in Bonita, if you're going to allow this type of use, is along Old 41. It makes the most sense. It's the most pedestrian-friendly, most pedestrian-oriented, and those are the kind of things I would think that you'd want to have. So in its present form, this ordinance would put my client out of business, at least in the current location. I think it's important to note that one of the benefits behind something like this is, at least in this case, my client has purchased a piece of property, certainly didn't purchase it at the time with the intent of having a mobile food vendor on it, but what happened is he's removed the old buildings, the trash that was on the property, he has cleaned it up, he's paved a portion of it, he's put fences down, landscaping, he has a grease trap that he's put on the site, he has the water, electricity hookup to this. My point being that he's actually cleaned up the property, made it look better and more compatible, if you will, to the Old 41 area. There was a couple of comments that were made. One, Alexis had indicated that one of the goals was to put, and maybe I misunderstood this, and if I did, I apologize, but it sounded to me like she said one of the goals was to put mobile food vendors on a level playing field with the brick and mortar restaurants. I would suggest to you that that's not what you should be trying to do. They're not the same thing. They're entirely different animals. and there's really no need to put them on a level playing field, if you will, because they're so different. Arlene at one point had indicated that it would be good to have mobile food vendors on developed lots with brick and mortar buildings. But at the same time, that's what's going to be prevented in this ordinance along Old 41. I mean, what I don't quite understand is why not let the mobile food vendors stay, and at the point in time when development comes back to Bonita, Southwest Florida, you're going to get people that are going to build on those sites. The existence or the location of the mobile food vendor is not going to prevent them from being able to do so. All it does is give that property owner some method to recoup some of his daily expenses on the property, the taxes he pays for the sewer hookup, whether he's got somebody there or not. The point being that it gives him a way to cover at least some of the debt service. The property's being used, the use has resulted in the site being cleaned up and improved, and a job has been created. I would suggest to you that we shouldn't be so quick to take that away. I do appreciate the fact that Carl Schwing, John Dolmer, all of the other staff, they've been very open, transparent about this. They've been very willing to talk to us and to try and work through this issue. In our particular case, my preference would be to see that this ordinance not be adopted. If it is adopted, what I'm going to suggest to you is that some significant revisions need to be made. I'm also going to suggest to you that someone like the tenant that Phil Pugh has currently, Rick Price, he should be grandfathered in and allowed to remain in the current location. I appreciate your time. I'm happy to answer any questions that I can. Thank you.
Thank you. Anything else, gentlemen? Oh, please.
Hi, my name is Rick Price, and I'm the owner of the Hungry Hound Dogs food cart. And I just want to say, you know, I appreciate everybody entertaining and taking the time and making sure that the way we move forward in Bonita Springs is the right way. I know for a fact in just the 4 or 5 months that I've been established out there that we've started having customers come in from as far away as Rapallo, Vasari, Mediterra, and they name it as their favorite place to go to sit down and have a hot dog after a round of golf or whatever. The point is we are bringing new people, new faces in to see Bonita Springs, and they do notice the park, they do notice the Veterans Memorial, and I think that's more of what we need, not less of what we're doing. And as long as the folks that do come in with these mobile food carts are in the same vision as Bonita Springs, I don't see why they shouldn't be allowed to proliferate, because in that proliferation brings a whole new face to Bonita Springs, and it does make it a more popular destination to go. I appreciate your time. Thank you.
Thank you. Anyone else?
Hi again, I'm Christy Sofer with the NOS truck, and I just want to agree with Rick, and the food trucks do actually encourage the businesses and the people to come. There's actually food apps now where they look for the trucks. We've had people that have come from LA and New York, and they want to find the trucks, and they've come downtown Bonita and said, hey, I finally found a food truck. There's only two of you in Bonita. So it does bring people. And I wanted to ask about why the restriction of the 500 feet from the churches and schools. Couldn't they be included in the letter of no objection? That's it for me. Thank you.
Okay, thank you. Anyone else? Well, I think we've uncovered some things that we need to correct in this. It is a first shot at it, so it's very understandable. Everything has to start somewhere, but I think we have some very good suggestions and some good direction in which to continue this.
Anything very specific as to Old 41 or grandfathering?
Well, I mean, the grandfathering I think should be immediate, number one. The number 2, the 3-day maximum, I don't
And
think
when I say
that's...
grandfather, that could be an amortization clause. Amortization would be where the existing food trucks would not necessarily be grandfathered, but could be amortized over a period of years. That would mean that the use would be removed after a given time based on their economic investment in the area. So depending on the intensity of what they went forward, for example, the toilet on the vacant lot, and taking your toilet with you, obviously you can't do that. You know, they should be allowed a certain amount of time to recoup their economic investment, and that would be an amortization clause as opposed to a grandfather clause, which would run forever.
Do we have to reach a decision on this today?
No, I'm just looking for input, so for next draft.
Yeah.
We have the people that are here in existence, we have them nervous about it, so I think we need to calm those fears. This, in my mind, I totally reject this as it's presented today. It needs to come back to us. In my mind, it needs to come back with a more positive outlook. And one of the things I think it needs is to be in the old 41 overlay area. And it needs to have provisions for the 5 or whatever we're going to have in the old 41 area, 3 or 2 or whatever the magic number is. But we need to encourage that, and the first thing. And then the second thing that comes to my mind is this is all going to end when a use for that property appears. That when somebody gets ready to buy that lot and build brick and mortar on it, that food cart is going to disappear. So it's not something that we're designing forever and ever and ever. This is a temporary use of this facility until, and the instant the city decides to announces their development for Bamboo Village, all the empty lots on 041 will all at once have brick and mortar come on them.
Hopefully in our lifetime. Yeah.
So I look at this as it's presented here today. I don't see anything that we can work with. I think it needs to be started from ground zero with another approach.
If I could comment, Mr. Chairman, unless
Sure,
come on up.
Come on up, Charles.
Thank you. I'm sorry, Charles Bassinet. One thing on the, if the ordinance does go forward and you consider a grandfather provision, the grandfathering, I would suggest to you, particularly in my client's situation, should be as to the site itself, not to the tenant, the current tenant. And the reason I say that is that my client was the one who spent all the money getting the site cleared, improved, and so to give a grandfather to the tenant doesn't necessarily solve the problem. I mean, it's not that I agree necessarily with the ordinance, but if you decide to go forward with it, then certainly we would want a grandfather provision or a lengthy amortization process that deals with the site as opposed to just the tenant in this case. And thank you very much for letting me come back.
Sam.
I would think that if we're going to consider that it goes with the land and not the particular vendor, that there should be some restrictions or requirements for the architecture of this vending cart or whatever it is, as opposed to parking a pickup there and selling a hot dog. So I think there's some requirements that we need to have as a city, if it's going to stay there for a while, that it's part of the city and not just an aberration.
Well,
So
there were some things in there, I believe.
there were
that
some
addressed
things,
that.
so out of hand to dismiss this, I don't think would be correct. I think that we need to find some standards that would be applicable. If we like the hot dog stand that's there now, then are there some components of that are visually what we want to see in others, then maybe we should use that as a standard or take that as a starting point. Just saying that I don't think we should allow any vendor there that would be tied to the property or the property tied to approval or grandfathering, because that could be disastrous if it's tied to the land and we have no control.
Would we want to do also potentially something like, certain cities do it with taxi cabs, like a medallion service where you could get the licenses per medallion, and That's another way of looking at this.
How does that work now?
I know in bigger cities, and I'm looking at Houston, and what Houston set up was a food dealer's permit, a mobile food unit medallion, and this was set up, started in 1999, but then revised in 2007. Any person who wants to have a mobile food unit, other than restricted operations mobile food units, because I think that's, when we call food stand, I think that's what we're talking about, is a restricted operations mobile food unit, has to obtain an individual medallion from a health officer, and those medallions, they have a limit on them. So we're able to limit, and that takes care of proliferation. So you have it set up into two styles. You have it set up where you have the truly mobile food unit, the taco person who's set up into a parking lot and really does business on Friday and Saturday night, but rest of the time is dormant. You have others that spent extensive sums on site development, and they are a restricted operations mobile food unit, and have it set up into that type of standard so that the people who do move around, you avoid the proliferation. The people who are stationary in a location as a temporary use until such time that there's bricks and mortars on that vacant lot, they too have a regulation, but it's a different regulation.
I think that works pretty well, because with the stationary, it becomes an object out there on the site, where it may be. And so as an object, it takes on the same physical characteristics and importance as a building. And therefore, that's why I think some restrictions go hand in hand with that. On things that are mobile, I think there still should be some sort of aesthetic restrictions on what can be placed, for the sake of all the people who have put in a lot of money in their buildings and property. It would work for them as well, or I'm sure they would have a concern in that regard.
Anything else, gentlemen?
If I may.
Let me talk with staff a little bit and maybe work on developing a different concept.
Okay.
I'd just like to reiterate, my main objection, to echo what Rex said, is the fact that the old 41 area is not included.
Yeah, that's got to be fixed.
If I just may add one further item.
Sure.
I believe the brick and mortar restaurant owners in the old 41 era were underrepresented today, not represented today. So when we come back to you with a modified, less restrictive regulations, we hope that they can be here as well, so we can really reach an equitable balance between those, because there certainly is competition. And
I think there's a big difference between types of vendors.
Yes.
Yes.
Yeah, we need to get that down.
About
a 5-minute break here before we get into the next item.
Wonderful.
We're adjourned for 5.
5 minutes.